Wasted money on cures. Forgot how to fix myself. They say that time is free. Then why is it so precious? Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. Time is running out. Time is running out. Lately I've lost my track. I've sailed the deeper seas, hoping to find something to bring back better times. Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. But time is running out. 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 Time is running. Time is running out. But time is running out. What if my best days are over? They can't be over. They can't be over now. Time is running out. What if my best days are over? They can't be over now. Time is running out. Time is running out. Time is running out.
Good evening, everybody. It's John here from Tutor to welcome you along to another of our live streams for A-Level Law. Tonight, we're concentrating on Civil Courts and ADR. We'll talk a little bit more about what that all means in a few moments or two. If you've not joined us in one of these live streams before, Liz and Sarah are going to deliver 30 minutes or so of fairly fast-paced revision activities. They'll ask some questions with very short responses. If you can respond by giving us your answers in the chat window, that would be great. A big warm welcome, of course, to anybody who's watching this on replay. You can take a little bit more time over the questions and have a think about what your responses would be. So I said Liz and Sarah, so let me introduce them both. On the left-hand side of the screen, I've got Liz, and on the right-hand side, I've got Sarah. Good evening to you both.
Hiya.
Right, a quick reminder to you as well that the PowerPoint that Liz and Sarah are about to use will be available to download as soon as this live stream is finished, so you can go through the questions again in your own time if you want to. And this, of course, is being recorded, so you can always watch it again. Right, I'll hand over to our two experts. Should we start, Liz? Shall we get started?
Yeah, sounds good. Okay, so the first activity which we've got this evening is altered vowels. So pretty self-explanatory, hopefully. We will get a phrase and the vowels have been altered. So what you have got to work out is what the correct term is, you identifying what the correct vowel should be. So if you think you know what it is, pop it in the chat. These are all key terms and phrases associated with civil courts and ADR. So we shall reveal the first one. And the first one is the civil procedure rules. So when you're studying civil courts and ADR, it's really important to have a good understanding of, what the civil process is, because that's quite different to the criminal process. So the civil procedural rules are the central rules which govern that process and the expectations of both the parties. Okay, we'll move on to the next one. This one's quite hard, I think, but this is another slightly longer 3-word phrase. If you think that you know it, again, pop it in the chat, and we can reveal that this is alternative dispute resolution. So alternative dispute resolution is a generic phrase for kind of methods of resolving a dispute without going through litigation. So a formal court process. And there are lots of different methods. You've got negotiation, mediation, etc. And you need to have some knowledge of what these different types of ADR. But it's really actively encouraged. So I always say to my students when we're talking about the civil procedure rules and the process that there's something very ironic about the civil procedure rules and the process, and actually all they're trying to do is discourage parties from actually getting to court. They want you to use ADR. So we'll move on to the next one. This is again a little bit tricky, but if you think you know what it is, do pop it in the chat. We can reveal that this key phrase is a pre-action protocol. So pre-action protocol is a list of things that a claimant has to do prior to submitting their claim. So it's very different, a civil case versus a criminal one. In a criminal case, if you're a victim of a crime, you'll report it to the police, or the police might have arrived at an incident. They'll potentially arrest and charge the defendant, and then the CPS undertake the prosecution. It's very different. If you are a claimant and you've been wronged, somebody's been negligent towards you and caused you a loss, you can't ring the negligence police. It doesn't work like that in civil law. A claimant has got to instigate a claim, and if they consult a solicitor or they do some research online, they will find that there's a pre-action protocol, and that's a list of things they have to do before submitting the claim form. And it will include things like writing to the defendant saying, look, I believe that you have caused me a loss and that you are liable. Could you respond to this letter, or I will be instigating a claim. And we'll move on to the next one. And our next one is on the screen. So again, this is quite a tricky one. This is a phrase which is part of the civil process. So again, pop it in the chat. And we can reveal that the answer to this one is directions questionnaire. So hopefully, if you're studying this topic, you will know that once a claim has been filed and they've got a response from the defendant, that the defendant wants to defend the claim and it is going to progress potentially to a court hearing, both parties will be sent a directions questionnaire. And this is a questionnaire to find out some more details about the case, because on the claim form, only basic information will be required. And actually, if it's going to progress to court, a lot more information is needed in order to identify what track it is that the case is going to be allocated to. So both parties complete the directions questionnaire. Okay, so next we have got the 60-second challenge. So we have got 4 tracks, and what you need to do is match the letters on the left to the numbers on the right. Okay, so you can just pop them in the chat. We'll start the clock now. Very dramatic music for us there. So we can reveal that the correct answers are as is shown on the screen. So some of you might be looking at this thinking, oh, I have only heard of 3 of those tracks. That's because I think it was in October 2023 they introduced a new track. So for years and years we've been teaching there is a 3-track system, and now we actually have a 4-track system. The new track is the intermediate track. What distinguishes between the tracks primarily is the amount of money that's being claimed. So small claims is claims up to 10,000, but they've got a lower threshold for personal injury, which is now £1,500. The fast is 10 and 25. Intermediate, this new one, is 25 to 100,000. They're still quite high value cases, but they're not too complex. So they're limited to, I think it's 3 days and 2 expert witnesses per side. Only cases where you can claim damages. And now the multi-track is claims over £100,000, whereas it used to be that the multi-track was claims over £25,000. So heading into the summer exams this year, do familiarise yourself with those new tracks. Okay, we will move on to the next activity. So this is 4-3-2-1, where you have got to list that number of items for each question. So we shall reveal. So can you please put into the chat 4 civil courts, 3 forms of ADR, the names of the 2 parties to a civil case, and the civil standard of proof. We will start your 2 minutes now.
5, 4, 3, 2, 1.
Answers coming into the chat. Right. Fantastic. So ADR, there are 4. So if you've done 4 within the time, you can start to think about the names. Yeah. In the chat.
Five, 4, 3, 2, 1.
Okay, so that is our time up. Thank you to those of you that have put your answers in the chat. So we can reveal the answers. So there are 4 civil courts, and actually they're demonstrated on the screen here. From the top is the lowest court down to the Supreme Court, which is the highest. So you've got the county, the high, the Court of Appeal and the Supreme Court are the 4 courts in the civil hierarchy. Really important to highlight that the civil hierarchy and the criminal hierarchy are separate. There are some courts that you will see their names in both. So the High Court has got multiple divisions, some which hear criminal appeals, others that hear civil. The Court of Appeals got 2 separate divisions, but the Supreme Court is quite unique. So the Supreme Court is the only court which sits and hears both criminal and civil appeals. So we'll now move on to 3. So 3 types of ADR: negotiation, mediation, conciliation. You also could have had arbitration, or you could have had tribunals. So tribunals are a form of alternative dispute resolution also. The next slide then will show us that the names of the 2 parties to a civil case are claimant and defendant. Really important not to call the kind of suffering party a victim. That is a criminal phrase, not civil. And finally, 1, the civil standard of proof is a balance of probabilities. Again, another way, another kind of key difference to criminal law, the threshold of proof, which is the standard of proof, is lots lower. You have to prove on the balance of probabilities, more likely than not. The defendant, is liable in order for liability to be established. It's much higher in criminal, where you have to prove beyond reasonable doubt that a defendant is guilty to secure a conviction. Okay, we'll move on to our next one. So this will be the final activity with me. We'll hand over to Sarah. And we are doing the chili quiz. So you've got 30 seconds to answer 3 questions, and the hotter the chili, the harder the question. So we will reveal the question. Okay, 30 seconds, off we go. Again, pop your answers in the chat. Over halfway through the time. Okay, so we can reveal that the answers are, so the Supreme Court is the final court of civil appeal. You've got no further kind of opportunity to appeal from there. And question number 2, a party's got 21 days to submit a request to appeal. So once there has been a court hearing and a decision of liability, maybe the order of damages, then you've got 3 weeks in order to submit the appeal request. It's not automatic that you will get a right to appeal. You have to have grounds for appeal in order for that appeal to be heard. And lastly, the kind of appeal process, it depends whether the trial was heard in the county court or the high court, but also will differentiate depending upon what type of judge heard the original trial. So if the original trial was heard in the county court by a circuit judge, an inferior judge, it will then go to the high court. Okay, fantastic. Thank you, everybody. We will move on to Sarah for the next activities.
Hey everyone. So for this particular activity, we're going to play categorise. So you have 60 seconds. You've got 8 pieces of information on the screen, and the idea is that you match them to the correct term. So in the chat, you can pop negotiation and the numbers that correlate to negotiation. Same with mediation and tribunals. If you're playing at home, you can do the same, or you could pop that on paper. So John, do you want to start the clock? Okay, so that was quite quick. If you're playing at home, you could pause for a little longer. If you're playing live, I can see in the chat there's some answers. If you want to double check your answers now, so the correct answers are, thank you, John, negotiation. We know that negotiation tends to just involve the 2 parties or the parties involved in the case. It's a non-binding outcome. It's the least formal outcome, and it can be done either in person, by writing, whether that's formal writing or online by email or other platforms. So negotiation is the least formal of our alternate dispute resolution. With mediation, we do have some third-party involvement. So the third party is not there to give their opinion or a legally binding outcome. As you can see there, it's also a non-binding outcome, but the mediator would be there to act as a go-between between the parties and allow both parties to have their say. The third party must be agreed by the claimant and the defendant. With negotiation and mediation, again, most least formal options, and they are non-binding. You can actually make them binding by signing a contract afterwards, but on the face value of them, without that contract, they are non-binding options. Tribunal finally then is a binding outcome, much more like a court proceeding. So we've got a much more formal process with a tribunal, and we do get a legally binding outcome at the end of a tribunal. So fantastic for those people who got it right. Well done. And we'll go into the next quiz. So with this one, we have confusing pairs. So you have to look at the key terms on the screen. So in this particular one, we've got 2 courts and then the descriptions. And the aim is to decide whether you think they are true, in fact, that the key terms do match their definitions, or whether they're confused and they've swapped around. So the first one that we have there is the High Court, and the description is that it's a civil trial court and it's the lowest in the hierarchy. We also have County Court. It's another civil trial court, but this one has divisional appeal courts. So if you think that they're true, pop into the chat, or if you're playing at home, write it down that it's true for that one if you believe they are to be true. Or if you think that they're confused, you can put a C in the chat for confused or a T in the chat for true. Thanks, Mariam, for your answer. And if we want to reveal the correct answer, please, John. It is, of course, false. So well done, Mariam. The county court is the civil trial court that's the lowest in the hierarchy. So we call this a court of first instance. It's where you can start a claim. And the high court usually would be just for appeal cases. There are some rarer cases, some of high value or complex cases that can start in the high court. But typically, the high court would be an appellate court. There's 3 divisions within the High Court that hear different civil matters. Next question, please. So again, same process. You can say that they're true by typing in a T into the chat, or they're confused by typing in a C. So this one looks at the burden of proof and the standard of proof in civil cases. So the burden of proof definition says that it's on a balance of probabilities, and the standard of proof definition on the screen says that it's on the claimant to prove liabilities. This is a little bit harder because they are linked, but are they the right way around, or do you think they're confused? So again, you can use the chat, or if you're playing at home, you could make a note of your answer for this one. And if we reveal the correct answer, please, John. This one was also confused. So quite similar because they both relate to civil liabilities and the proving of fault. The standard of proof is that balance of probabilities, which if you were listening in earlier, Liz did mention, the balance of probabilities in a civil case is much lower than that of a criminal case, where it is beyond all reasonable doubt in a criminal case. So the balance of probabilities, we're looking for a 49 to 51%. 51% being in favour of the claimant if they are saying that the defendant's at fault, and that's for the judge to decide. The burden of proof is on the claimant, so it's for the claimant to prove that liability. It's not for the defendant to actually prove that they were not at fault. It's for the claimant to prove that they were at fault with the required evidence. Thanks, John. Okay, so another confusing pairs. This time we have pre-action protocols, which again was on an earlier quiz, so you might have picked up some information on these already. And the definition here is it's a claim form that's submitted to the court to initiate a claim. And then we also have the N1 claim form, which is a list of actions the claimant must complete prior to submitting the claim form. So again, same principle. Do you think they are the correct way around true? Or do you think they're confused and they need changing around? Feel free to pop your answers in the chat. And John, if you reveal the correct answer, please. It was another confused one on that particular one. So it's the N1 claim form that you would submit to the court to initiate the claim. You would submit that to the county court. And the pre-action protocols, as Liz discussed earlier, are a list of actions that the claimant must complete prior to submitting that form, which can include using alternate dispute resolution first, particularly if it's a small value claim. Next question, please. Do the key phrases match up to the definitions on this particular slide? So we have the multi-track, which says it's for claims over £100,000, And the immediate track, which Liz mentioned, is the new edition track, which was introduced in October 2023, which deals with claims of 25,000 to 100,000. Do we think that's true? Type in T. Or do we think that's confused also? Type in C. Fantastic. If we reveal the answer, please. That was true. We've got a truth this time. The multi-track does hear the highest value claims or the complex claims, and that new intermediate track, which has been introduced a sandwich between the multi-track and the existing fast track, hear the claims over £25,000, but up to a value of £100,000. And finally, are these confused or are these true? Negotiation is a direct discussion of the case between two parties with an aim to resolve the case. And mediation is where we have a third party intervention to facilitate discussions between the two parties. Do we think that they are true, T, or confused, C? And if you were just playing along with the categorise, you might have got some extra knowledge for this particular question too. Fab, some great answers in the chat, and you are correct in that one. It is true. So negotiation is the direct discussion between two parties, the least formal of all processes in ADR, and mediation, we do have that third party. Thank you. Okay, so finally, we're going to end on the big reveal. So we will give you some clues. It will start off quite challenging. The first clue will be quite open to potentially a few answers, so you can feel free to pop them in the chat or write them down at home. And then as we near the end of the fifth clue, hopefully it will become much clearer. So if we can have the first clue, please, John. So it's a type of track. Liz mentioned earlier there are 4 types of tracks now, and this particular one is a type of track. So you can write them in the chat if you think you might get it from that clue, although that's quite a vague clue, but if you can get it from that clue. And if we reveal the next clue, hopefully it might get a little bit easier. This particular track only allows a maximum of 2 expert witnesses per side, so a total of 4 in total for each side. Have we got the track yet? Would we know from that clue which track we're talking about? And the next clue, please, John. It's only used where the claimant is seeking monetary compensation. So where a claimant is wanting to seek an injunction or a specific performance, that usually wouldn't be allowed on this track unless it's in the interest of justice, and the judge can allow it on this track, but usually it's just for monetary compensation claims. We also have some fixed recovery costs in this particular track. And clue number 4, the hearing would last around 3 days. So it's kept to quite a strict timetable, again with the idea of keeping costs down. Fab. So we've got some tracks coming in on the chat. I've not yet seen the correct answer. So if we give a clue number 5, it deals with those claims between £25,000 and £100,000. Have we managed to guess that correct track? If we reveal the answer, please, John. It is, of course, that new intermediate track. And as Liz has already said, very important for your exams, particularly because it's a new area of law. If you're reading some of the outdated text, for instance, that might not be covered. So make sure that you are looking at all 4 of the tracks. We do have a Tutor to You blog that covers the immediate track introduction. It's a very good read, comprehension questions on there. So if you'd like to do a little bit further reading on intermediate track, check out the blog too.
Indeed, indeed we do. Thank you. Thanks so much to those of you who have participated on the chat window tonight. And of course, a massive, massive thank you to both Liz and Sarah for delivering those activities. Hopefully you found it useful. Give us a thumbs up in YouTube if you have. That helps get our message out there to as many people as possible. And of course, don't forget that the PowerPoint that Liz and Sarah have been using will be available as soon as this live stream finishes and this has been recorded. Now, that's our final live stream of 2024. We'll be back in the new year with a whole new set of live streams building up towards those big exams that are coming very, very soon. So until then, from Liz, Sarah, myself, everybody at Tutor to You, hope you have a lovely Christmas, have a great break, rest, recuperate, get yourself ready for a very busy 2025. Thanks everybody and good night.
Bye.